or in the future. He goes on to say, whilst it appears that the Data Protection Act may have been breached in this case, we don't have enough information to make a formal assessment. If your constituents would like us to assess this, they should complete and return the complaints form at the back of the enclosed leaflet. This is more PC plod than Batman and Robin. After 4 years of hitting a brick wall, what confidence should Mr. and Mrs. Horton have that completing and returning a complaints form on the back of a leaflet will lead to do anything other than more bureaucracy and delay? And the reason why I feel this sense of frustration, particularly in this case, is because when I've tried to deal with this by writing to the agencies concerned, all I have received was the inhuman and cold response of Sir Humphrey at his most dull, lethargic and indifferent. I actually spoke soon afterwards to the Information Commissioner himself, Mr. Christopher Graham, in my office and raised this case with him personally, but nothing has happened. Quite simply, what is the point of having an Information Commissioner's office to police the Data Protection Act if the response is worthy of the Circumlocution Office in Little Dorrit by Charles Dickens? And to quote from that book, the Circumlocution Office was, as everybody knows without being told, the most important department under government. If another gunpowder plot had been discovered half an hour before the lighting of the match, nobody would have been justified in saving the Parliament until there had been half a score of boards, half a bushel of minutes, several sacks of official memoranda, and a family vault full of ungrammatical correspondence on the part of the Circumlocution Office. Whatever was required to be done, the Circumlocution Office was beforehand with all the public departments in the art of perceiving how not to do it. Now, under different circumstances, the sloth of public agencies might be a cause for a wry joke or just mere annoyance. But in this case, the state has stood idly by for 4 years while an elderly couple were systematically persecuted. Don and Anita have been forced to spend a substantial chunk of their life savings defending themselves against baseless legal claims from the individual in question. And what is the result? Nothing. There are 3 problems here. First, Don and Anita's identity was released by the Job Centre Plus. Secondly, the judicial system has not brought the individual to justice. Yes, there are multi-agency difficulties and due process, but we must have a justice system that is concerned with justice. Victims should be protected and criminals prosecuted. Thirdly, had Don and Anita gone to trial, their identities would have been released anyway because of our rules around witness anonymity. Mr. Deputy Speaker, we must protect the decent people who do the right thing. And this applies not just for Mr. and Mrs. Horton, but for the future. As of today, there is no compensation for the Hortons in sight. It is not so much a matter of what they might technically be entitled to. If they had the strength and finance to fight tooth and nail through every court in Europe, it's just that nobody seems interested. Nobody seems bothered to help. What is the point of coming to Parliament and making laws if when people do the right thing, they suffer? What is the point of laws at all if the good and decent suffer because of incompetence and bureaucracy? We should know that the character of the state is revealed not in its ambitions, but in its actions, not in its policy, but in its implementation. The characters of the Job Centre Plus and the court system have been woeful. Now, I know that Mr. and Mrs. Horton are in the House today, and they will want to hear the Minister's reply. Before I sit down, I should add that I have been very grateful for the Minister's concern in this, particularly in my discussions with him. And I also very much appreciate that he is going to meet Mr. and Mrs. Horton after this debate.
Mr. Deputy Speaker, I'm extremely grateful to my honourable friend for the way he's helped myself and my officials prepare for this, so I can give him as much of a constructive answer and advice as I'm able to do. He will understand the restrictions that apply on me about dealing with an individual case. But I have to say, Mr. Deputy Speaker, I think my honourable friend's constituents are extremely well served by the way my honourable friend has raised their case, and they have an extremely doughty champion on their behalf. He has raised a number of issues. They include criminal evidence, the handling of witness statements made for the purposes of criminal proceedings, and the protection of witnesses from intimidation and harassment. And I will respond to these in my capacity as the Minister responsible for criminal justice issues. But he's also raised issues about the process followed by the Department for Work and Pensions in relation to the investigation of benefit fraud, and expressed concern about the processes adopted by the Information Commissioner in dealing with allegations of the mishandling of data, and I will deal with those 2 points later. And so it is not appropriate for me as a Government Minister to comment on any particular case, but I want to make it absolutely clear that I wholly share my honourable friend's concern that those who perform a public duty by informing on those who commit benefit fraud or any offence should not be subjected to harassment. Society depends on courageous people who witness crime to come forward and report it and to give evidence. Witnesses are vital to our criminal justice system, and it is crucial that they receive appropriate support in giving evidence in criminal proceedings to ensure that justice is done. However, justice does also require us to ensure that the defendant has a fair trial. So when someone gives evidence about an alleged offence, they may be asked to make a signed witness statement, which will contain their name and address. And once the statement has been made, what happens to it depends on whether anyone is charged with an offence and prosecuted in the courts. And I understand that when taking a witness statement, Department of Work and Pensions investigators will explain to those giving statements that they may be asked or required to give evidence in court, and the signed statement includes wording to this effect. If no charge is brought, the matter will go no further. But if someone is charged, the prosecutor may wish to use the witness's evidence as part of the case against the accused. In these circumstances, the prosecutor must give copies of all the prosecution evidence to the defence in advance of the trial. Any witness statements will have the address of the witness removed, but not their name. This reflects the general long-standing principle of English common law that defendants have the right to know the identity of their accusers and to challenge the evidence against them. The Government takes the issue of witness intimidation very seriously. Witness intimidation is a criminal offence under Section 51 of the Criminal Justice and Public Order Act of 1994. This offence is punishable on conviction in the Crown Court with a maximum penalty of 5 years imprisonment or a fine or both. On conviction in the Magistrates' Court, the maximum penalty is 6 months imprisonment or a fine or both. And it is also an offence under the Protection from Harassment Act of 1997 for someone to pursue a course of conduct which amounts to harassment of another and which he knows or ought to know amounts to harassment of the other. The offence is punishable on conviction by a maximum of 6 months imprisonment or a fine not exceeding level 5 on the standard scale. There is also a more separate, more serious offence which is committed when the offender pursues a course of conduct which he knows or ought to know will cause the victim to fear violence. This offence carries a maximum penalty of 5 years imprisonment or a fine or both. A court sentencing someone convicted of either offence may also impose a restraining order prohibiting specified forms of behaviour, such as deliberate communication with the victim. And breach of a restraining order is a criminal offence, also punishable by up to 5 years imprisonment. But a civil remedy is also available under the Act, which enables a victim of harassment to seek an injunction against the person harassing them. This can be obtained without a conviction for harassment being secured. The investigation of allegations of intimidation or harassment is, of course, a matter for the police, and any decision to prosecute is the responsibility of the Crown Prosecution Service. Where a witness fears intimidation and harassment, there are a number of other ways that they can be supported before and during the trial. Before the trial, intimidation should be reported to the police, who can provide appropriate advice and support. Police forces can arrange for a witness and their family to relocate temporarily or permanently to a different neighbourhood in the area through the local housing authority. Where witnesses remain in their homes, a number of target hardening measures are available to improve home